Tonight, we need to talk about a case that has rocked a Tennessee community to its core. This isn't just about one man or even just one courtroom decision. It's about what happens when the system fails children and when the people rise up to say, enough. You're listening to Steph's Case Files, Truth Be Told. And this is the case of Joesph Dalton, the former Blount County teacher, and the decision that sparked outrage. The community is now fighting back. Joesph Dalton was once a trusted educator, one of those faces children knew as a coach. But he wasn't just a coach at one school. He was a floating PE teacher who moved throughout the elementary schools of East Tennessee, such as Friendsville, Lanier, Walland, Porter, Eagleton, and Townsend. But beneath that familiar role is a horrifying truth stretching back nearly 2 decades. The timeline starts in 2005. That's when the first documented allegations against Joesph Dalton began. Back then, Dalton was working with the Blount County school system. While the specifics of those early complaints remain protected or redacted in many documents, sources have confirmed that at least one involved inappropriate physical contact with a young student during PE. Then, over the next 15 years, the complaints kept coming. Reports were made by parents and students across multiple elementary schools. My own children went to Lanier during those years, so this affects me deeply as it could have been them. Some students say that they told teachers. Some say that they told school counselors. Some say that they told their parents who called administrators, but again, no formal charges, and Dalton remained in the classroom. He was no longer assigned to one school, but instead he became a floating PE teacher, meaning by 2015, new patterns began to emerge. A single school year that meant more access to more children and less consistent supervision from one specific principal or staff. Despite the mounting concerns that no public disciplinary record appeared, that is until September 2023 when a parent reported Dalton to law enforcement direct. The nature of that complaint? Inappropriate physical contact during a PE class. That was the complaint that finally broke through Dalton, and he was suspended without pay. And that same day, he resigned. In September of 2024, he pled guilty to 5 counts under Tennessee Code 39-13-101A3, offensive touching. These weren't harmless mistakes. These were criminal acts committed against children, but here's the part that stunned the community. Dalton didn't serve a single night in jail. No permanent conviction, no listing on the sex offender registry. And yes, he may even have his record expunged. And this wasn't sudden, according to the records. As I talked about many times, he had complaints 20 years ago. That's when it started. And in total, reach over 80 allegations. 80. And yet year after year after year, he continued to teach, to coach, to be around children until one day, one parent finally spoke up in 2023 and law enforcement intervened. After Dalton's guilty plea, the community outrage exploded. He had gotten judicial diversion. It's simply a way to give people a second chance with certain conditions. And after they complete a certain amount of probation, they are then given a second chance to have their record expunged. But when the sentence came down at the end of April 2025, the citizens' outrage really did explode, and concerned citizens started speaking up and having protests, and all sorts of things happened. Parents gathered and survivors began speaking out. So, The Blount County Commission issued resolution number 25-05-015 in May of 2025. The wording was clear. It said the commission held, quote, extreme concern and displeasure and disappointment with the justice system. But why? Joesph Dalton also did not surrender his teaching license. It is still valid, and he could easily go from one county to the other, not expecting them to check to see if there's any convictions out there, which, by the way, won't be if they're expunged. So let's put that into context. A man admitted to inappropriate physical contact with multiple children over a span of years and walked away with probation, a light tap on the wrist for what survivors describe as lifelong trauma. In our recent episode of Truth Be Told, we heard directly from those survivors. Young women now, adults who described being silenced. One shared how she felt sick every time she passed him in the school hallway. And another said, quote, I remember him touching my back during stretches and knowing it wasn't right. But nobody listened. Some of them reported, yet nothing changed. This wasn't just the failure of one man. It was a systematic collapse so that the commission had to take it further. They thanked the Blount County Board of Education for commissioning an independent third-party audit of every HR file from 2015 onward, digging into the misconduct reports and whether any patterns were ignored. And while the audit focused on recent years, we all know this problem started way long before 2015. But on May the 8th, 2025, came that resolution that they feel, once put in before the General Assembly, will pass. And that if we couldn't get justice from Joesph Dalton, at least we can change laws so that future children can be protected. It's not just a bold step, but a step to change the law itself. Here's what Blount County is now demanding from the Tennessee General Assembly. They are calling to make offensive touching of a minor a felony and not just a basic misdemeanor. They are also calling for an automatic revocation of teaching license of anyone convicted, regardless of judicial diversion, which is what he got away with. There's a fine line between judicial diversion and what it covers, what it don't. And we're going to talk about that just a little bit. But they also require all Tennessee school systems to track and report employee misconduct data statewide. This means that if the Board of Education decides to leave Joesph Dalton's license intact, that if he goes to another county, they'll be able to pull up his background and his HR records right away. They are also asking for a mandate that resignations during child-related investigations be flagged and reported to the Department of Education. I'm going to read you a few of the things that they said in detail, and then I want to go over why this was listed under a judicial in the first place and why I think he didn't qualify. Here's what the Blount County Commission says. The judicial system serves as a cornerstone of democracy and is intended to ensure fairness, accountability, and equal protection. The recently extremely displeasurable and disappointing judgment involving such heinous, horrific crimes against innocent children, 5 admitted counts under TCA 39-3-101A3, offensive touching. Whereas the judicial system serves as a cornerstone of democracy and is intended to ensure fairness and accountability and equal protection, whereas the recent extremely displeasurable and disappointing judgment involving such heinous crimes, horrific crimes against innocent children, 5 admitted counts under TCA 39-3-101A3, offensive touching, should never be considered as reasonable for such a long-standing history of allegations to result in a slap on the wrist punishment. And whereas this case concerning multiple allegations spanning over nearly 20 years of crimes committed against innocent children should have called for felony charges. Whereas in this case, concerning multiple allegations spanning over nearly 20 years of crimes against any children should be called for. Those felony charges receiving just a punishment fitting the serious nature of the criminal activity, whereas in this case concerning multiple allegations spanning over nearly 20 years of crimes against innocent children should have called for a felony, receiving a just punishment fitting the serious nature of the criminal activity, rather than a judgment that amounts to less than a slap on the wrist. 5 counts of offensive touching, and whereas initial reports of these crimes being in the first made public spurred this commission to adopt resolution number 24-09-013 in September. 5 counts of offensively touching students, and whereas initial reports of these crimes being the first made public spurred this commission to adopt this resolution. On September the 9th, 2024, to be investigated further to better determine, quote, who knew what and when did they know, unquote. That is very powerful. They also said, we formally express our extreme concern, displeasure, and disappointment regarding the local justice system's insufficient actions concerning this particular case in which an admitted offender of misconduct against innocent children was not sufficiently punished given the 20-year history that involved over 80 complaints of misconduct, and that the offender A, B, C, and D did not have to spend even one night in jail, despite the possibility of serving jail time, and did not have his name listed on any sexual offenders list, despite the possibility of having his name so listed, and did not have to surrender his teaching license to help ensure that he cannot continue committing the same heinous acts despite such surrender being completely possible and in the public interest. No more hiding behind resignations. No more quiet transfers. No more passing the problem down the hallway or down the district. Blount County has drawn a line, but they're also calling on you as parents and educators and lawmakers to stand with them to ensure that next time justice means protection and not just silence. Judicial diversion in Tennessee was established in 1989 with the enactment of the Tennessee Criminal Sentencing Reform Act. Remember, judicial diversion is what has allowed Joesph Dalton to receive only 6 months probation instead of harsher punishment. This legislation introduced judicial diversion as an alternative sentencing option for certain first-time offenders coded in the Tennessee Code 40-35-31. You see, under this statute, qualified defendants may plead guilty and be placed on probation without a formal judgment of guilt. If they successfully complete the probationary period, the charge can be dismissed and expunged from the record. In mid-2011, the Tennessee Supreme Court adopted Rule 17A to standardize the process for judicial diversion across the state. This rule provided a uniform order of deferral from trial judges to use. When granting this rule provided a uniform order of deferral from trial judges, meaning that they simply look at a list to see what conditions have been met. But it's gone over a lot of amendments to refine the eligibility. Supreme Court Rule 17A outlines the official order of the deferral for judicial diversion in Tennessee. It provides standardized form and process that they go through, sort of like a checklist. What does it do well? Well, it gives them the checklist, and then it clarifies conditions such as probation, restitution, community service, and then it explains the consequences, like if the defendant fails to comply, stating such a possible conviction and sentencing and so on. But it also protects records to ensure that proper documentation is in place for expungement if the defendant successfully completes diversion. 17A makes the judicial diversion process more transparent and less consistent, but it's also important because it helps to decide the terms under which the diversion is even granted in the first place. Judicial diversion does exclude certain offenses and individuals, like they aren't eligible if they've ever had a prior felony, which Joesph Dalton did not. and they are charged with a sexual offense as defined in TCA 40-39-202. Well, let's take a look. Here's the disqualifications: rape of a child, aggravated sexual battery, sexual exploitation of a minor, solicitation of a minor, statutory rape. But the point is, if someone is convicted or pleads guilty to any offense requiring sex offender registration or serious sexual offenses involving children, they should not be granted judicial diversion under the Tennessee law. Or if a case does involve a plea to a lesser non-sexual offense, diversion might be technically possible, but such plea deals are rare, controversial, and right now the latest one is facing public and legal scrutiny right here in my hometown. But let's talk about other cases in where this law has been accepted. Joshua Anthony Williams, aged 18, pled guilty to statutory rape involving his 13-year-old cousin. Originally charged with rape and sexual battery, he accepted a plea deal for statutory rape, a Class E felony in Knoxville, just last year in 2024. The court granted Williams judicial diversion, placing him on probation for 6 years. During this period, he was required to register as a sex offender. Upon successful completion, the conviction could be expunged. Of course, the court weighed factors such as his age, his lack of prior criminal history, and the circumstances of the offense, but the court deemed the diversion appropriate under the specific circumstances. In Pickett County, Tennessee, back in 2001, Charlie Logan, then the sheriff of Pickett County, was indicted on multiple counts, including aggravated rape and statutory rape. He pleaded guilty to 4 counts. They denied Logan's request for judicial diversion, sentencing him to 2 consecutive 2-year terms for each count. The denial was upheld on appeal, with the court emphasizing the severity of the offenses and the abuse of his position of authority. The court highlighted his role as a law enforcement officer and exploitation of his position, determining that these factors outweighed arguments for diversion. But what does 17A actually say about diversion in itself? I wanted to read you a section of TCA 40-39-202 straight from the TBI's own website, the Tennessee Bureau of Investigation. I quote, "Employed or practices a vocation," unquote, meaning any full-time or part-time employment in the state with or without compensation, or employed practices a vocation, that means any part-time, full-time, doesn't matter, that involves counseling, coaching, teaching, supervising, volunteering, or working with minors in any way, regardless of the period of employment, whether the employment is financially compensated, volunteered, or performed for the purpose of any government or education benefit. Did they not consider Joesph Dalton as an authoritative figure in the Blount County school system? Did they not take that into account? Offender against children means any sexual offender, violent sexual offender, violent juvenile sexual offender, if the victim is 12 age of years or less. But what do they consider violent? Shouldn't the welfare of the mind of the child that is violated be considered a violent offense? There were incidences between Dalton and the children that to me is grooming and a sexual assault on children from an authoritative figure. Are we living in the world where the line is so gray that we don't see it right there in black and white? In 2005 in Warren County, Tennessee, Pamela Rogers, a former teacher, was charged with multiple counts of sexual battery by an authoritative figure and statutory rape involving a 13-year-old student. The outcome of that was that Pamela Rogers pled no contest to 4 charges of sexual battery, and she received an 8-year suspended sentence, including 270 days in jail and 7 years and 3 months of probation. She was also required to register as a sex offender for life. Where was the exact count of sexual battery by an authoritative figure? Because I'm pretty sure if he was charged with that exact statute, that they may have looked at Rule 17A or the TCA Rule A a little bit closer. In this case, judicial diversion was not granted. In fact, It is so rare that you have to ask yourself, how deep does the Dalton name go in Blount County? So let's talk about what the district attorney said and, more importantly, what was left out. First off, DA Ryan Desmond pointed to the lack of contact with what he called the intimate body parts of the victims. But let's break that down for a second. There's a documented incident from September the 22nd, 2023 at Friendsville Elementary. Dalton hugged a student tightly and swayed her back and forth between his legs. Between his legs? Excuse me. How is that not perceived as intimate parts or perceived as a violation of children? And yes, even through clothing, Tennessee law still considers that enough to meet the threshold for sexual battery by an authoritative figure. Remember Rule 17A? Yet, there were 2 incidences just one day apart in September of 2023 where most would agree that the intimate parts of victims were violated. On September the 28th, 2023, Joesph Dalton was caught on video trying to kiss a 9-year-old girl. The next day, more video of Dalton tickling a 12-year-old female and touching her breast surfaced. This same day, September 29th, he was seen on video also bouncing a 10-year-old female student against his body. So, I'm confused on what the DA constitutes intimate versus non-intimate parts of children, but in my opinion, breast and lips are intimate on any part of human, child, or adult. Here's where it gets even more frustrating. The prosecution originally declined the case because they said they couldn't prove sexual gratification. But here's the truth. Tennessee law does not require proof of gratification. What the law does require is for a jury to believe that a reasonable person should see the behavior and think, that was probably done for sexual gratification. That's it. It's not about proving what was in Dalton's mind beyond a shadow of a doubt. It's about what a reasonable person would conclude based on the actions. And when you hear that a grown man swayed a child between his legs, tried to kiss them and touch their breast, how many of us can say that that seems reasonable? The Tennessee Board of Commissions has taken the right step in the right direction to get harsher laws passed and even diversion removed for all and any offenses, including minor children. But we have a long way to go when it comes to law reform for our schools and the children that they are sworn to protect. Tonight, let's not forget what this is really about. Let's remember the brave students and parents who spoke up, but also remember Let's remember the brave students and parents who spoke up, but also let's remember the parents who trusted the system and were betrayed. Let's remember the trauma that 80 voices tried to share that were ignored and not heard. If you're listening from Blount County or from anywhere in Tennessee, call your representatives and demand stronger laws. Ask why Joesph Dalton is still free because his case is no longer local. It's statewide. In fact, 32-year-old Chad Brooks, social studies teacher and coach at West High School in Knoxville, Tennessee, was arrested after 7 p.m. on May the 10th by Morristown, Tennessee police. This comes after a Knox County grand jury indicted Brooks after KPD's Special Crimes Unit began investigating reports that he engaged in inappropriate behavior with both past and current students. Back in April, he was placed on paid administrative leave while the school and law enforcement looked into the allegations. Brooks was booked into the Roger D. Wilson detention facility but has been released with a GPS monitor, according to court records. And in this case, the Knoxville Police Department is asking anyone impacted by this case or anyone who has information about other incidences of child abuse or statutory rape to come forward. But how can you expect people to come forward if you don't listen? I don't know every detail involved in the Brooks case, and I don't know his past, but I do know this. This is happening way too much, and our children are not being listened to. What will happen to Brooks? Will he get judicial diversion? Will there be more children harmed? The sentencing of Joesph Dalton for just 6 months of supervised probation ignited a wave of public outcry in Blount County. Residents expressed profound disappointment, feeling that the punishment did not match the severity of the offenses. Protesters gathered outside the Blount County Courthouse holding signs and demanding justice for the victims. We live in a country where our voices have the right to be heard, but stand in a county where the rights of our children go more and more unprotected every day. I think it's time that our justice system recognizes children as precious souls instead of human numbers. I think it's time we as parents stand up and say, enough is enough. As of May the 12th, 2025, it has been confirmed that the Board of Education is now aware of Joesph Dalton, the conviction, and the repeated allegations. It'll be interesting to see what they decide to do. They have not yet released a statement. I want to thank you for joining me today. Make sure you follow me on every social media platform. I'm on TikTok and YouTube. It's the same username, at Steph's Case Files. This is Steph's Case Files. Stay aware, stay vocal, and as always, stay relentless.